Welcome, everyone. So welcome to the fourth event organized by the Space Arbitration Association. And I think I recognize a lot of you, so I think by now you're probably familiar with this. But just as a reminder, so I founded the Space Arbitration Association in November last year. And my idea behind it was to create a forum of discussion between the space arbitration community, the arbitration community and the space law community, to create a room where we can discuss what the best dispute resolution mechanism could be for space disputes. So this is the fourth out of 8 events that we will have throughout the year. And the next and fifth event will take place at the end of June. And the topic will be whether we can arbitrate space collision cases. Registration is not yet open, but if you follow us on LinkedIn, you will get notified when you can register. And before we go to today's topic, I just wanted to thank Thorsten and Chiara and SpaceWatch Global again for their support of the association and for hosting our events. I think none of this would have been possible without them. So really thank you. And for everyone who's not yet receiving their newsletters, if you're interested in the space industry, you can follow them. And I think it gives a really good overview over what's going on in the sector. So with this, we will turn to today's conference. And I don't know if you remember, but last month, we discussed what room there is for private actors in space disputes. So it was focused more on commercial disputes. And today we will talk about states in outer space. And so today's panel is constituted of 4 experts in public international law. And we will hear today from Dr. Daniel Muller, who will provide us with an overview of international space law governing activities by states in outer space. From Professor Irmgard Marboe, who will tell us about possible disputes over liability for damage caused by space objects. From Natalie Reid, who will discuss the potential for disputes over ownership of space resources. And finally, from Alexandra Soucek, who will tell us about the European Space Agency. I will introduce each of them before they speak. But we will start with the first speaker, Daniel Muller, and I will now introduce him. So Daniel is a founding partner of Phare Avocats in Paris. He has been working in international dispute settlement for 20 years and has represented states as counsel and advocate on numerous occasions before international courts and tribunals, including before the International Court of Justice, the International Tribunal for the Law of the Sea, the European Court of Human Rights, the Court of Justice of the European Union, and before arbitral tribunals constituted under the United Nations Convention on the Law of the Sea and other ad hoc arbitral tribunals. So as I mentioned, Daniel will tell us about the general legal framework that governs space activities by states. So with this, Daniel, the floor is yours.
Thank you very much, Laura. And thank you also to Thorsten and Chiara to organize this event. I'm very thrilled to be able to speak on this issue, which, to be quite frank, in the first place, is not one of the usual subjects we discuss when we discuss with states about dispute settlement. But there might be reasons for them, and we will probably come back to them a little bit later on in my presentation. So first of all, Laura has asked me to speak about the general framework of space activities set up by states and the different dispute resolution mechanisms which are available to states in this area and in general international law generally. But I should start to say that space law is interstate law at the first place, not only by name, and we always speak about international space law, but also, and most importantly, by its object and by its sources. Its object first, of course, space law concerns the activities of states in the outer space. This is how it was set up. And at the beginning, all these activities were conducted mainly by states. Private actors came in much later and actually quite recently in this field. The reasons might be the cost and the nature of these activities which were conducted at the beginning: research, military uses, communication, and the commercial aspect comes much later. But on the other hand, these activities also take place not in areas where states enjoy sovereign rights, but just above them. So a lot of the rules concerning space activities addresses issues which what might happen if the use of space by some states will cause damage to the territory of other states. One of the satellites falls down, etc., what will happen? But I think Irmgard will speak about the Liability Convention, which addresses those issues. On the other hand, the sources of international space law are hard international law. So international space law has started to develop actually only once the activities in space have started. Sputnik was launched on 4th of October 1957, and then the General Assembly of the United Nations, only a month after the Sputnik event, has started to develop the international space law. So there's the first resolution of the General Assembly of 11th of November in 1957, which didn't concern directly the international space activities, but which concerned disarmament. And the Assembly expressed concerns about the use of space in terms of military use. And then the General Assembly of the United Nations took the issue of space activities very seriously and started to develop, according to its function, development of international law, some quite important rules which are today fully recognized as rules of space law through resolutions. The first resolution, or the most important resolution, I think, is the resolution of 1963 on the Declaration of Legal Principles governing activities of states in the exploration and use of outer space. Notably, these are only resolutions of the General Assembly, and those resolutions have no binding legal effect as such. However, given that the state the most directly concerned, those days the United States and the USSR, accepted those resolutions, they actually are seen as part of hard law governing space activities today. And then a bunch of other resolutions established by the General Assembly have put into place the main legal framework, international conventions on space activities. 1967 on the Outer Space Treaty is actually a resolution of the General Assembly. It's a framework convention which does not contain much detail, and it mainly recalls that states have to conduct those activities in accordance with international law, which proves, on the other hand, that this is actually real international law. Also in 1967, the Assembly adopted the Agreement on the Rescue of Astronauts, which becomes an international convention. In 1971, we have the next important convention on international liability for damages caused by space objects. So Irmgard will speak about this one, I think. And then 1974, the Convention on Registration of Objects launched into outer space. The last big convention in space law is the 1979 convention, also a General Assembly resolution, which is called the Moon Treaty, or the Agreement governing the activities of states on the Moon and other celestial bodies. So 2 comments on this. First of all this is hard international interstate law. It's treaties. Most of them have been signed and ratified by quite a number of states. 1979 Moon Treaty is an exception to this because it has only 18 state parties because of some rules which are not considered to be general international law today. But on the other hand, it's nothing else than just a patchwork of rules and quite broad principles put together as the need arose, or at least when the General Assembly thought that it would be good to legislate in this certain area. There's no general overarching collection of rules on outer space yet. And this fragmentation of space law is probably further exacerbated by the relatively large number of regional cooperation agreements, so the European Space Agency, for instance, and technical arrangements concerning, for instance, the International Space Station, and quite a big number of bilateral agreements. But because this law, the space law, is nothing more and nothing less than international law, the dispute settlement is supposed to follow the rules and principles established for the resolution of disputes between states under international law. And so it might be surprising, but there is no obligation to resolve disputes by recourse to courts and tribunals in international law. There is no mandatory judge. And even if this is quite often difficult to understand for us lawyers, because we think that the tribunal and the court is the most faithful expression of justice and law, well, that's what we have in international law. But the most we have, the farthest we can go is Article 2.3 of the United Nations Charter, which simply sets out that the member states shall settle their international disputes by peaceful means. But the International Court of Justice has said, in a quite recent decision, obligation to negotiate an access to the Pacific Ocean, that this paragraph does set out only a general duty to settle disputes in a manner that preserves international peace and security, but there's no indication in this provision that the parties to a dispute are required to resort to a specific method of settlement. And the Charter also lists a number of possible methodologies which states can use: negotiations, inquiries, mediation, conciliation, arbitration, and judicial settlement, courts and tribunals. However, it's always only for the states to choose and pick whatever they consider the most useful to them and the most suitable for the resolution of specific disputes. So states have under international a choice in respect of dispute resolution and dispute settlement, and even more so when it comes to arbitration and judicial settlement. Without consent of the state concerned, even the International Court of Justice can't do nothing. And this irrespective of the quite different question whether the state is right or wrong. So this consent can be given in advance or once the dispute has arisen. But let's see what states have committed to in terms of dispute resolution in the international instruments concerning outer space. The short answer to this is pretty much nothing. So, of course, the 1963 General Assembly resolution does not contain any provision on dispute settlement specifically. It's a resolution of a General Assembly, and it would be quite bizarre, to use this word, if it would contain, strong obligations concerning dispute resolution. It does only include a kind of a consultation obligation in case a state considers that another state uses space to its detriment or in a way that it will cause damage to it. But this is not really an obligation as such to settle a dispute, because even an obligation to consult does not entail an obligation to agree. The Space Treaty, 1967 Space Treaty, contains no evolution compared to the 1963 resolution. It actually only recalls what the resolution already contains in its Article 9. The 1979 Moon Treaty, so I will skip the Liability Convention, the 1979 Moon Treaty is a little bit different, because first of all, the United States draft text contained a provision which provided for mandatory recourse to the International Court of Justice in terms of dispute resolution. But this met with very strong resistance in the General Assembly, probably not so much because of the principle of dispute resolution in itself, but also of the very strong resentments against the court in those years. And therefore, Article 15 of the Moon Treaty only provides for mandatory consultations. So it's already a little bit a step forward, mandatory consultations. In a case that a state considers that another state does not fulfill its obligations under the treaty. In case no satisfactory outcome is reached during these consultations, Article 15 only sends back the state concerned to find means to settle their disputes by other peaceful means, and that's the term. So we are pretty much back where we were at the beginning, regional agreements show, on the other hand, that states are less reluctant to accept arbitration in those circumstances. So the ESA Convention is an example which provides for arbitration. There are others, Inmarsat, EUMATSAT, Intelsat, and Eutelsat. They all contain provisions on mandatory arbitration in case of disputes between the member states and the organization. However, I do have doubts whether this concerns classical space law or space activities, because most of the time it concerns only obligations of pure cooperation. Those treaties are cooperation agreements concerning the question how states could together conduct activities in outer space. But of course, all this does not mean that there will never be space arbitration between states, because states can always accept to go to arbitration or to the International Court of Justice. Some states have accepted to the jurisdiction of the International Court of Justice in full, but those directly concerned, United States, USSR, of course, don't. But of course, on a case-by-case basis, it's entirely possible that states will go to the International Court of Justice or to international space arbitration.
Daniel, one question. Could there not be a convention providing for general consent to arbitration for states as well?
So that's not entirely hypothetical, because the International Law Association, which is an organization of international lawyers which gather together to discuss interesting issues about international law, pretty much on every kind of subject. So the International Law Association has started in 1978 to study the question of settlement of space law disputes. And under the direction of Professor Bockstiegel, which is still one of the most prominent international arbitration lawyers, the International Law Association has adopted a first draft convention on settlement of space law disputes. It's 1984. So this convention actually provides, of the draft, because it's still only a draft, that all disputes concerning space activities should be settled in accordance with the rules of this convention. The convention distinguishes between non-binding procedures, so procedures which states can go to without an outcome which is mandatory for them, which they have to respect, like exchange of views or conciliation. And on the other hand, there are binding methods of dispute settlement, like arbitration or judicial settlement. Those states can choose and pick between three options. First option is the International Tribunal for Space Law, which of course does not exist, but which is provided for under this convention. The second option is the International Court of Justice, and the third option is arbitration. States can put their choice as they want. If a dispute arises between two states and their choices don't correspond, then it will necessarily be an arbitral tribunal which will decide their case. So this system is very largely influenced by the United Nations Conference on the Law of the Sea and the United Nations Convention on the Law of the Sea, which embodies the very same system. Now the question, what is the name of the draft? The name of the draft is Draft Convention on the Settlement of Space Law Disputes.
Yes. And for example, who could represent the interest of humanity in interstate space disputes if there were disputes? Because I think given that this convention was influenced by UNCLOS, this was a topic that was at the heart of the dispute at the time, correct?
So it doesn't come really clearly out from the draft convention on the settlement of space law disputes, neither the first draft of 1984, which I was just speaking about, nor the second, which is the final draft, which was adopted by the International Law Association in 1998 in Taipei. But of course, under UNCLOS, there is a real system which provides for dispute settlement in the interest of humankind. because under UNCLOS there are areas in the sea, especially the seabed, which are managed in the interest of all states of the world. But there are international organizations which take care of this. So there's the authority and the enterprise. And those two entities have standing before the Tribunal of the Law of the Sea in order to defend this case. Also against private individuals, by the way, even if the tribunal in Hamburg has not seen any such cases until now, but this will certainly come. So even if ITLOS might, and UNCLOS, so International Tribunal of the Law of the Sea and the United Nations Convention on the Law of the Sea, are good reference points for space law disputes, I think you should not forget that those two institutions, ITLOS and the United Nations Conference on the Law of the Sea, actually have dealt with a whole package. It's not only dispute settlement, it's also the material rules which govern sea. And as long as we don't have this for outer space, I think a self-standing convention on dispute settlement will probably never be signed by states, which will only be ready to accept dispute settlement when they know what kind of rules they have to accept.
Okay, thank you, Daniel. That was very interesting. We will now turn to our second speaker, Professor Marboe, and she will talk to us about possible disputes by states in outer space related to liability for damage caused by space objects and about their possible dispute resolution. So Professor Irmgard Marboe is a professor of international law at the University of Vienna in Austria. She has been the head of the Austrian National Point of Contact for Space Law of the European Center for Space Law since 2008. And as a regular member of the Austrian delegation to UN COPUS, she follows closely the debates in the Vienna-based UN Committee on the Peaceful Uses of Outer Space. And between 2008 and 2013, she was the chair of the Legal Subcommittee's Working Group on National Space Legislation. And in addition to her interest in space law, she is an expert in international investment law. I think all of us working in arbitration are well familiar with her book, because she has specialized in and widely published on the calculation of damages and compensation by international courts and tribunals. So Irmgard, we are now happy to hear from you. Thank you.
Thank you. Thank you very much for this very kind introduction, and thank you very much for the invitation to this highly important discussion on dispute settlement and arbitration or interstate arbitration, which is of course very interesting for me from the two perspectives of international investment law, which I have specialized on, and international space law. Today, the topic I was assigned by you is the Liability Convention, which provides for a claims commission. It's not really an arbitral tribunal, not really an arbitration procedure, but quite similar to that. And I would like to introduce the similarities and differences of this system of dispute settlement to international interstate arbitration. I have prepared a few slides just to guide you through my most important thoughts and try to share my screen. But I need to first do this and then start the presentation. Can you see it now?
Yes.
Can you see the presentation and in the correct mode, presentation mode, right? Okay, yes. So the topic you gave me, Laura, was risks of disputes over liability issues for harm caused by space objects, the Liability Convention and the Claims Commission. Indeed, the Liability Convention of 1972 creates a unique liability regime. The full title is Convention on International Liability for Damage. Let me start my timer that I don't talk too long. That's my most most high risk here. I take too much time. The Convention on International Liability for Damage Caused by Space Objects is the full title. And it tells us already what it is about. Very clearly, it is about damage caused by a space object. So it is not a liability which we know from general international law, which usually follows from an unlawful act. Generally, liability follows from responsibility. When a state has acted in a wrongful manner, violated international law, and then caused damage. And then the state is liable to pay compensation for such damage. Here, the system is totally different and unique. I can tell you, we don't have it in such distinct manner in our environmental law. Sometimes, it's said that there should be such a system, but it's not yet there. We don't have it in other areas. It's really unique, and the uniqueness is due to the hazardous nature of space activities. So the mere dangers and risks which come with the launching of a space object, which are putting into orbit, operation of a space object in orbit, is high risk and can cause high damage to people and people on the ground, and to other objects either on the ground, on Earth, or in outer space. So a high risk operation. And this is the main reason why the system hinges only on the damage caused by a space object. So it's not the act, the wrongful act or so, or activity, but the space object. And you only need to know the damage that is caused. The causation, of course, needs to be established, and the space object which caused it. But who then is liable? The launching state is liable. That's a term, a technical term, which is introduced already in the previous, already in the General Assembly Resolution of 1963, which was mentioned by Daniel, but then taken up in the Outer Space Treaty. And here in the Liability Convention, it's very precisely defined that there is more clarity about who is the launching state, which is the launching state. And we have 4 different options to define a launching state: a state which launches first or procures the launching, or a state from whose territory or facility a space object is launched. So this is the subject of liability. And this liability is also unique, namely absolute, for damage caused on the surface of the Earth or to aircraft in flight. And fault liability is established for damage caused elsewhere, meaning in outer space, for collisions in outer space, because damage can also be caused to other space objects and people in space stations, for example. So it's not on the ground, not in an aircraft, but in outer space. And here the notion of fault is introduced, because the difference is that the victims here are not really the totally innocent bystanders who have nothing to do with space activities, who do not profit and do not gain anything out of these activities, but they are also spacefaring actors, and they should know how to behave responsibly. So there is this element of fault, which is then introduced here, that only liability follows from fault if the state, if the damage is due to the fault of the state or the fault of the person for whom the state is responsible. It's also a very tricky notion, because it's not defined what fault is really, but we have some idea on responsible behavior. It has to do with negligence or negligent behavior or not, but it's not defined. This is, of course, subject of a lot of debate and discussions in academia and practice. But today we do not really talk about the merits or substantive issues of the liability regime, but rather on the dispute settlement, which is provided for in the Liability Convention, which takes quite some articles of the Liability Convention, quite clearly define the procedure, how and where to bring the claim. It is again state centralized. So the liability is state centralized to the state. The state is the liable, but also the victims are represented by the state. So either the state has suffered damage itself, or its nationals or permanent residents have suffered damage. Then this state can bring a claim, may present a claim to a launching state. How does does this come about? Through diplomatic channels, tells us the convention. And if there are no diplomatic relations between the two countries or two or more countries, if there is no diplomatic possibility here, then the UN Secretary General can also act as a channel through which such claims can be brought. This is also provided in the convention. So the UN Secretary General can help and transmit these claims. There is a time limit, 1 year after the occurrence of damage. And the convention states explicitly that also claims before national courts, administrative tribunals or agencies remain possible, but only alternatively, not cumulatively. So the state must decide, or the victims, if it's a private person, must decide which way they choose, which way they want to go. So either here, a claim commission or the liability conventions path or national courts, but they remain possible. The claim commission here then comes in if the settlement through diplomatic channels was unsuccessful within 1 year. And here the parties shall establish a claims commission at the request of either party. So there is sort of a compulsory dispute settlement mechanism that the states have agreed that they accept the competence of the Claims Commission under these conditions. So if 1 year unsuccessful negotiations took place, then one party can request establishment of a Claims Commission. This Claims Commission looks very much like an arbitral tribunal. It consists of 3 members as a rule. Every party appoints 1 member. Jointly, they choose a chairman. If this is not possible, the UN Secretary General chooses the chairman. Single membered claims commissions are possible if one of the parties does not make an appointment. But no increase in membership is possible, even if there are more claimant states or launching states, which is, of course, possible. So 3 members. So we can keep in mind the 3-member claims commission as a rule. The claims commission then decides on the merits of the claim for compensation and determines the amount of compensation payable, if any. Here, I find it interesting that the provisions of the convention are rather detailed and give us more guidance as we usually find in international law. When I published my book and other articles, it was not always the case that I found such clear rules on the determination of the amount of compensation. Here, the convention says it shall be determined in accordance with international law and the principles of justice and equity in order to provide such reparation in respect of the damage as will restore the person, natural or juridical, state or international organization on whose behalf the claim is presented, to the condition which would have existed if the damage had not occurred. So Article 12, I highlight here. This is interesting because it combines the law and equity. Equity is not always available in the calculation of damages and compensation. It has to be explicitly agreed upon. So we see here an explicit agreement on the state parties of the agreement that also justice and equity are a viable alternatives or possibilities to calculate compensation. However, the next part then of the paragraph brings us to the courts of principle of full reparation, which is taken from the law of state responsibility. This is interesting. So, because here we are again in the law of state responsibility, which I mentioned before, on unlawful acts, which then of course need to be fully repaired. Interesting that nevertheless, even in the absence of some unlawful act, we have the principle of full reparation here mentioned because the words are almost identical as those in the judgment of the Permanent Court of International Justice in the case Courts Factory, which is then also replicated in the ILC articles on state responsibility. So interesting what we have here, what we find here. The decision of the Commission, is it binding or is it not binding? The 2 ways, 2 answers to this. Do you see my time is over? I'm almost finished. The first sentence says it shall be final and binding if the parties have so agreed. Otherwise, the Commission shall render final and recommendatory award, which the parties shall consider in good faith. And the Commission shall state the reason for its decision or award. So this is very similar to arbitral awards. We find that. So an arbitral award usually is final and binding, but here we have an addition, we need an additional agreement. So it's not automatic. The convention as such, the liability convention as such, does not establish the binding nature of the decision, but provides for and encourages actually the states to accept the binding nature. And how does it do so? In the resolution of 1971, when the convention was presented to the General Assembly after discussions in the COPUOS and the drafting process has finished and so on, the General Assembly put the text of the convention to the attention to the General Assembly and recommended it to be signed and ratified by the members of the United Nations, and also said that in paragraph 3, any state may, on becoming a party to the convention, declare that it will recognize as binding in relation to any other state accepting the same obligation the decision of the Claims Commission concerning any dispute to which it may become a party, to recognition of a binding nature. And what is the result? Do we have a lot of declarations? No, unfortunately not. We don't have only 8 declarations so far. We can find them in the United Nations Treaty Series. You see, Austria has done so when it ratified, Canada, Denmark, Ireland, New Zealand, Norway, Sweden, and the Netherlands. This is a very low number, unfortunately. This has to do with some reluctance generally of states to accept binding decisions of supranational dispute settlement organs, and also in a very general manner. So this reflects also the reluctance of many states to accept the jurisdiction of the International Court of Justice, for example, which Daniel has mentioned before. So there's room to improve. So here this is the Austrian declaration, just a very small letters, but here how you can find it in the United Nations Treaty Series. Application, perhaps we can talk later on. I now want to, my last slide, to highlight how can we improve the enforcement of the Liability Convention. Is it possible to bring binding declaration ex post? Can states that are already party to the Liability Convention make such a declaration? The wording of the General Assembly resolution does not properly allow it. So we can say, yes, it would be the object and purpose of the convention and so on, and it should be possible. But some commentators say, well, it would be good to have perhaps a new UN General Assembly resolution to remind states and encourage states to consider to make such a declaration, even ex post, and that it is possible and that they should be encouraged to improve the enforcement of the Liability Convention. What about international organizations? No declarations have been made so far, for example, by ISA or UMITSAT, who have accepted the obligations and rights and obligations under the Liability Convention, but have not made such a declaration to accept the binding nature of the Claims Commission's decision. There is another, it is again the question, does the resolution allow at all for international organizations to make such a declaration, because it only mentions the possibility of states to do so. But perhaps Alex can enlighten us a bit further what his opinions are with respect to ISA, whether it could consider such a declaration on accepting the binding nature of the Claims Commission's decision. With this, I would stop and look forward to the discussion later. Thank you very much.
Thank you, Irmgard. So I have a few questions. First, if I'm not mistaken, the Liability Convention and the Claims Commission have never been used in practice. So do you think that it is still relevant, or that in light of this, it is not very useful in practice?
I can actually then skip to my this one slide I have prepared, perhaps. You have it. It's fine here, because here this is the Cosmos incident. So it was once an incident which came close to the application. It was not really the application of the convention and not the Claims Commission, but the fact that at that time in 1978 already the Liability Convention existed, and the procedure of the Claims Commission was in theory available. Of course, I would submit helped the bilateral negotiations. So, you know, you have in the background sort of the danger, or, you know, that one of the states can bring a claim and request the establishment of the claims commission helps, of course, I would say, the bilateral negotiations. That the two countries, in that case the Soviet Union and Canada, came to an agreement on the amount of compensation, which in that case was 3 million Canadian dollars for this damage which occurred due to the crash of the Soviet satellite on Canadian territory. So I would say that the fact that we have such a procedure in place already, and all the state parties of the convention have accepted it and must fear, so to say, if they do not find an agreement after 1 year, the other party may request the establishment of such a commission, helps and is helpful. Of course, it can be improved, but we have to be grateful, I would say, that we have such a vehicle already in place.
Yes, and maybe with the current accumulation of more and more objects, it will soon be tested again. So we might be seeing if it's relevant or not. But one other question: are there any other dispute resolution mechanisms that could apply to disputes over damages caused by space objects outside of the Liability Convention?
Yes, as Daniel already mentioned, we have all the full range of means of dispute settlement which are mentioned in the United Nations Charter. So interstate disputes should be solved by peaceful means. Under Article 33 of the UN Charter, we have a list of possible ways of dispute settlement, negotiation, and also arbitration and adjudication. But here we then have to see whether that all these dispute settlement mechanisms depend on the consent of the two disputing parties. This is due to the sovereignty of states. States have always to agree on a way of dispute settlement. And we have a whole range of possibilities, whether they are only the two of them, or they need a mediator, or they have conciliation, or they accept jurisprudence on arbitral tribunals. So there's this whole range of interstate dispute settlement mechanism, which we know from the United Nations Charter and practice.
Thank you. So now we have seen one area of disputes, which is damages caused by space objects and potential liability for the states that launched those objects. And now we will turn to another possible area of disputes, which is the ownership of space resources. And we will have the pleasure of hearing from Natalie Reid, and I will introduce her. So Natalie Reid is co-chair of the Public International Law Practice and partner in the International Dispute Resolution Group of Debevoise and Plimpton, an international law firm headquartered in New York. Her practice focuses on public international law, international arbitration, and complex cross-border litigation matters. She regularly advises and represents states, multinational corporations, international organizations, and non-governmental organizations in legal proceedings in domestic and international fora. As part of that practice, she acts as counsel in interstate treaty and commercial arbitrations conducted under the rules of the major arbitral institutions. She also regularly sits as an arbitrator in a wide range of commercial cases. So I hand the microphone over to you, Natalie. Thank you for joining us today.
Very much, Laura, and to Daniel and Irmgard for doing such a fantastic job of setting the table, so to speak, for sort of the general public international legal framework and one specific kind of area of interaction between states in space that can and has given rise to disputes. As Laura mentioned, I'm going to talk about another potential area of substantive disputes between states concerning property rights and ownership of space resources. And this is an area which is getting increased attention. And in part, again, this is with underlying developments in different domestic jurisdictions and increased attention just in the market and from investors. So when we talk about space resources, It's not a hypothetical discussion. A lot of the interest and the focus on it is driven by an increased interest and increased investment in the underlying economic activity. So what are we talking about? In large part, we're talking about recovering and excavating or extracting space resources, otherwise known colloquially as space mining. So it's materials, minerals that can be extracted from asteroids or near Earth objects, including water. So why the focus in space mining? I've touched on one or a couple of reasons. We have increased interest and increased investment, but it's also an area that I think is ripe for disputes. Not only is there a lot of money and a lot of political attention paid there, but there are a number of actors, state and non-state actors. There is an unclear legal framework, which we've heard a little bit about, and I'll talk more about. And there are high stakes involved, which I'll also get into a little bit more detail. In the context of interstate disputes, you're dealing with some very big questions that, again, the international law community has dealt with before in the context of dealing with law of the sea and questions about the seabed. Who gets to decide what gets done in this area in space? When we're dealing with economic activity and getting down to some fairly granular issues, who gets to issue licenses for economic activity? Who gets to shape or spur or benefit from this kind of investment? And again, this is not a hypothetical question. A recent study has estimated that the global space mining market last year was worth more than $1 billion, that's with a B, US dollars. And over the next 5 years, that amount of investment is expected to triple. So again, a lot of interest being paid in this area. So when we're talking about disputes, and I mentioned that we're dealing in an area where there is a lack of clarity, and in some cases, just a lack of law. So Daniel, in explaining, sort of just the general legal framework, touched on a number of, the foundational treaties and agreements here. I'm going to focus on 2 of them because they really, in some way, sort of reflect and have crystallized these competing views of states about these big questions. Who can stake claim to space resources? So the first treaty, of course, is the Outer Space Treaty. As Daniel mentioned, it's been ratified by many countries. I think the latest count is over 100 countries. And the critical principle there, reflected in Article 2, is a principle of non-appropriation of outer space. But in the context of non-appropriation, and again, as has been discussed, this was at a time when sort of the focus was on relations between states. So non-appropriation in this context has been generally understood to mean non-appropriation by a claim of sovereignty, occupation, or any other means. The Outer Space Treaty does not have any specific express language on property rights. So that's sort of one body in the firmament, so to speak. The second one is the 1979 Moon Agreement, which, as Daniel has already mentioned, is ratified by fewer than 20 states. And in this one, it reflects, again, influenced quite a lot by the UN Convention on the Law of the Sea, and that approach to dealing with potential of shared natural resources. The Moon Agreement classifies the moon and its natural resources as the common heritage of mankind, and expressly states that, not the moon or its subsurface or any natural resources that form part of that can be the property of the state, an intergovernmental organization, a non-governmental organization, or a person. But because you don't have that many states that have, signed up to the Moon Treaty, the dominant, international agreement in this space remains the Outer Space Treaty, which, as I mentioned, doesn't have specific provisions on property rights. So in that gap, or potential gap, but gap in the international treaty framework, what we have seen is states increasingly creating or recognizing property rights under their domestic laws. So several states have already passed domestic legislation concerning the rights to explore, exploit, and utilize space resources by private entities and individuals in their jurisdictions. So that includes, for example, the United States, Luxembourg, the UAE, and Japan. Now, those are just the states that have already passed domestic legislation. I think we can expect to see further legislation in this area as private companies and investors in other jurisdictions, such as the United Kingdom and Canada, are developing mining technologies intended to be deployed in space and in space resources. So out of this lacunae in public international law and the treaty framework, see increased regulatory activity by states under domestic laws. And the states that have already legislated, or the states that we think are likely to legislate, haven't been silent about their view of what international law does or does not permit in this area. Again, this is an area of current fervent debate and dialogue, among and between states and other international actors. But again, recently what we've seen, an agreement in many ways sort of launched or spurred, driven by the United States, the Artemis Accords. All of the states that I just mentioned and a number of others, I think almost a dozen others, signed on to the Artemis Accords, which was launched by the United States NASA, which is intended to establish a set of principles for peaceful international cooperation, but really to expressly recognize the views of those states that creating or recognizing property rights of private entities for space resources is not incompatible with the non-appropriation principle of the Outer Space Treaty. Again, this is not an uncontroversial position, but when we deal in the area of public international law, as those who focus on how customary international law is developed, for example, the activities and the public statements of states who are most involved in particular conduct, or in this case, new sectors, new markets, new activities, is given particular weight. So what does that mean for disputes? So there are a number of organizations in the non-governmental, sort of intergovernmental space that are seeking to form a bridge between the views of states like those that signed the Artemis Accords, saying nothing wrong with recognizing property rights in space, and those that have already signed on to the Moon Treaty or may be inclined that way, to see, so can we form a common solution among states for the governance of space resources? So that includes, for example, the Working Group on Space Resources, which is housed in the Committee on the Peaceful Uses of Outer Space. Also includes groups like the Hague International Space Resources Working Group, which has recently published a set of building blocks that are intended to form the starting point for a discussion and potentially a future governance framework, again, seeking consensus in this area. But you still will have, for all the reasons that I noted earlier, the prospect of disputes, including disputes between states. So what happens when you do have a legal dispute between states? Now, it's not that states, private actors have not arbitrated disputes. They have, and they do. One of the questions I saw in the Q&A is whether the ICSID Convention, for example, could apply to disputes in outer space that are framed as investment disputes. The short answer there, we can definitely get into it a little bit more in the Q&A session, is yes, we're already seeing those kinds of cases. But when we're talking about interstate disputes, one of the innovations in the international dispute resolution space has been the activity of the Permanent Court of Arbitration in publishing a set of sector-specific rules for arbitration disputes. So these are the optional rules for arbitration disputes relating to outer space activities, which are based on really the leading set of ad hoc arbitration rules, the UNCITRAL arbitration rules. And the idea is, as we mentioned, there are the classic options for interstate dispute resolution including arbitration. But as those of us who are active in international dispute resolution know, if you have to build everything once you find yourself in a dispute, it can frequently be a barrier to even getting to resolution and engaging in the substance and the merits of the dispute. So having pre-drafted rules, especially rules that are administered by a known and respected and reliable arbitral institution, can frequently help facilitate the resolution of disputes through arbitration by providing that forum, by providing the rules, so that, to pick up on a point that Irmgard mentioned earlier, states would know what they were signing up to. So the PCA rules are, in many respects, a reflection of an innovation that the PCA itself has done, which is to issue, sort of sector-specific rules based on UNCITRAL that have been fairly successful in other fields. In the outer space field, however, our experience has been interesting, I think is the best way to put it. The rules were issued about 10 years ago, but so far as can be discerned from publicly available information, they have not been applied in a dispute between states. And it's possible that there have been confidential arbitrations between states, because as we know, this is a feature of arbitration generally and of these rules in particular, but at least as far as we can tell, doesn't seem to have been used. And again, as I mentioned earlier, it's not that states haven't arbitrated disputes related to outer space. They've done so under the auspices of other arbitral institutions and under the auspices of the PCA, but just not under the optional outer space rules. They've done so under the older versions of the UNCITRAL arbitration rules. So again, for an international dispute practitioner, a public international lawyer interested in how we can facilitate the pacific settlement of disputes between states in this area, there are, sort of the question will arise. So what is it about the rules that might explain the lack of uptake? I think there may be three answers to that. The first is novelty. I mentioned they've been around for 10 years. In the grand scheme of things, that's actually not a huge amount of time. Some of the disputes that I mentioned that have been arbitrated arose under contracts or agreements with arbitration clauses that already selected other rules. So if you think about it, there is a time lag. You have to select the rules, have them in your contract, agreement, or treaty, and then invoke them. But we are getting initial reports of some states including the rules in recent agreements and treaties, so we may yet see some uptake later. Second reason, lack of knowledge. Most of the actors who have been involved in space-related arbitrations are commercial actors, private parties. And the PCA, to this day, is still best known among states and international organizations and private parties who contract with those actors. So it may just be a question of greater knowledge and greater familiarity. Last, the question of, is there a need for a specialized set of rules? In this area, I don't think there's a question that it would be concern about fitness for purpose, because the PCA optional rules are designed in a number of different features, specifically to facilitate space-related disputes. But it may be that experienced and sophisticated users of arbitration who've already arbitrated space-related disputes can expect that they can, already build, if not a better mousetrap, an equivalent mousetrap. But for all the reasons that I mentioned earlier, it may very well be that the PCA rules or similar efforts by, again, established arbitral players can be most useful in attracting wary states. You have a familiar and trusted institution, you have familiar rules adapted for the industry, but allowing for flexibility, and the prospect of assistance, because a couple of the features focused on industry or sector specific needs include specialized arbitrator lists and specialized expert selection. So to kind of summarize before pausing, we're in an area when we deal with extraction of space resources where you have all of the ingredients for continued and potentially increased disputes, certainly among the range of actors involved, but including states. When we think about the kinds of disputes that might arise between states, we already know that they happen. And the question is, are they going to be arbitrated? That I think will be, again, sort of a three-point answer. The first is, will states become familiar and comfortable enough with the prospect of resolution of the dispute by arbitration, including to a binding resolution? Second, will they make it public so that we will actually be aware that this is happening and can follow the development of the law? Third, will we see, I think, some of the keys to the success of arbitration so that you can see, for example, a lessening of heat of political attention and a focus on a resolution or in clarifying some of the continuing tricky legal questions that remain in this space. So I'll pause there.
Thank you, Natalie. Just to add one point to what you said, the PCA rules for outer space disputes even provide for a 5-member tribunal, specifically to cater to states, because most of the interstate arbitrations have 5-member tribunals, not 3. So they clearly would like to attract interstate space disputes, but we will see if it will happen. So one question for you, what do you think can we learn from resource arbitrations on Earth about similar disputes arising maybe over resources in outer space?
I think we can learn a lot. So if we think about and again, I think of the person who put the ICSID-related question in the Q&A. If we think about the significant body of investment arbitration disputes, or in some cases interstate disputes involving natural resources, but let's think about the mining sector, for example. We have a number of, I think, sort of analogs or parallels. High stakes. You have lots of risks, including known risks and unknown risks, but with considerable potential upside. You have a long time horizon, so you're dealing with substantial capital investment with expectation of returns over time. And what that means when you put the two of those together, high stakes and long time horizon, is an incentive. It's like a structural incentive to resolve disputes, to facilitate continued work in the area. Or if you're shut out of your investment or your activity, significant incentive to initiate a claim to recover for, sort of your lost profits or what you had hoped to gain. Another, I think, sort of lesson that you can learn from mining disputes on Earth is the impact of markets and technological innovations, right? So economic incentives within the market can play a very important role in the decision-making, not just of companies and investors, but in states. When it comes to, sort of how are you going to design a regulatory scheme? How are you going to do so in anticipation of what disputes may or may not arise, and in order to avoid or mitigate those? And with technological breakthroughs, we have seen again in sort of on the ground in the relations between sort of mining investors and states, that significant technological breakthroughs that essentially allow different kinds of projects to become economically feasible or expand the scope of extraction activities can change the calculus of players, including states. So understanding how states have historically reacted in the regulatory space on Earth can perhaps give us some indication of where things may be heading when it comes to space mining. The last lesson, I'd say sort of a general lesson when it comes to, sort of international arbitration already, is the absence of precedent, which has its critics, as we know, in, sort of the investor state space, and those who are concerned about the fragmentation of international law can still help to attract potential users, so states that might be leery of being locked in. And it allows space and flexibility for the clarification of tricky questions of international law and jurisprudential development over time. And here, the ability to have specialized decision makers who are aware of all of the different factors and moving pieces in space may also be a key factor. We've seen this and the benefits that it can bring, both for states and investors in arbitration. And that can, again, give us an indication of where things can go if states start using space arbitration mechanisms more. So I will stop there. There's so much more to be said, but I'm really eager to hear from Alex.
Thank you very much, Natalie. Yes, so we have the honor of having Alexander Soucek with us today. Alexander is the head of the Public International Law Division of the European Space Agency. He also serves as the secretary of the International Space Station Coordination Committee and represents ESA in the legal subcommittee of the UN COPUS. He earned degrees in laws from Salzburg University, Austria, and in space studies from the International Space University in Strasbourg in France. He is an alumnus of the Hague Academy of International Law and a former visiting researcher at the Space Policy Institute at the George Washington University. He lectures on space law and the law of international organizations and published books, commentaries, and articles on those subjects. He is the corresponding member of the International Academy of Astronautics and a member of the International Institute of Space Law, of the European Center for Space Law, and also serves as the director of the World Space Week Association. So thank you, Alex, for joining us, and we are looking forward to hearing from you.
Thank you, Laura. Can I just make a comm check? Do you hear me loud and clear? Perfect, excellent, thank you. And hello to everyone. I cannot say good evening or good morning because I see in the attendees list that it's a bit all over the world, which is wonderful. So thank you also Torsten and everyone for this opportunity. And thanks to my colleagues who have spoken so far. It was a pleasure listening to you. And what I try at the very end of this let's say contributions is to add a bit the perspective of an international intergovernmental organization. Now, to start with, allow me that I don't jump right away into dispute resolution and arbitration, but give you, especially those of you who are not familiar with ESA, a little sort of 120-second tutorial on what the European Space Agency actually is from a legal perspective. And that's simple. It's an international intergovernmental organization. I call it very often a textbook IGO. With that, I want to say it has all the constituents, the ingredients it needs to be qualified under public international law as an IGO, but it has not much more than that. Obviously, it has its specificities in its founding treaty, but it's a rather straightforward organization. And that's important to understand also when we come to dispute resolution. It has legal personality under public international law, obviously, and it has two organs. One is the Director General, that's the executive organ, and the other one is the Council, the plenary organ where the member states of ESA can express their will and contribute to the common will of the Council and of ESA. Now, the founding treaty of ESA, that's an international treaty called the Convention for the Establishment of a European Space Agency. So very straightforward. That was signed back in 1975 and entered into force in 1980, 5 years later. And today ESA has 22 member states, but that is not all. It has more than that. It also has 3 associate members. So that's sort of a pre-step before full membership. Soon, actually, 4 associate members. In a few weeks, we will hopefully welcome Slovakia as the 4th associate member to ESA. Canada has a very special relation with ESA as a cooperating state that has certain rights and obligations under that legal framework that we have together. And beyond that, so beyond the states that are institutionally linked to ESA, there is, of course, a wide variety of international partners. And that is already the bridge to what I want to tell you in a few minutes from now on. Over the decades, ESA has entered into more than 500 international agreements with its partners. I think we're now at 530 or 32. And that means in particular with other intergovernmental organizations or international institutions, but also with governments of non-member states. So you can imagine this represents a very rich body of law developed over time and practice also in implementing international cooperation. Now, why did I give you this context at the beginning? Because in the remainder of my presentation time, I want to look into 3 different aspects as concerns dispute resolution that arise from this very complex nature of ISA. Arbitration between the member states of ISA and between ISA and its member states. That's one aspect. The second one is dispute resolution in our procurement contracts, because ISA's one of the let's say the raison d'etre of ISA is actually to foster European space industry and to place procurement contracts with European space industry. And then last but not least, we look into the field that is very close to my heart because of my position here, and that's the international, public international law domain. Now, arbitration among ISA and its member states. It's very important, and this is maybe this angle that I try to bring into this webinar, that ISA in itself, like any other IGO, is a mechanism of international cooperation among the member states. And this brings, of course, the potential risk of discord or disputes. Now, evidently, you have sort of a staggered mechanism already provided for in the convention to mitigate the potential for discord or disputes even arising. But once they are there, and once you have no other means of settling them in a way that avoids arbitration, then indeed there is in the convention a very specific article, it's Article 17, on dispute settlement. And the arbitration procedure may be used if it has, as I just said, not been possible to settle the dispute amicably through the council, so the plenary organ that I've just mentioned to you. Now, where is such an arbitration procedure applicable? It's applicable for disputes between the member states, 1 or 2 or more of the member states on each side, but also between the member states and the agency itself, concerning, and that's important because that's the scope, concerning the application and the interpretation of the founding treaty itself, of the convention. That includes, by the way, also what we call the Annex 1, and I haven't shown you this, but this is the ISA convention. It fits in this little booklet, and you can find it online also. There's nothing secret about it, so I invite you to dig into the convention. Annex 1 on privileges and immunities is a very important one, and you will find such an arbitration procedure foreseen also in the host agreements between ISA and those of its member states that host an establishment, a center of ISA on its territory. Now, the Article 17 on arbitration is rather short, like the whole ISA convention is rather straightforward and short. So over time, there was, of course, the necessity to provide for additional rules and regulations, and the Council has done so specifically in this field. Council adopted what we call additional rules on arbitration, and they constitute, together with the primary law source of Article 17, the basis of arbitration procedures between the member states and between the member states and ISA. Then, second part, now we look into more the private area, that's the procurement contracts with industry in our member states. I will touch that briefly because I want to focus more time then on the international agreements, but it's of course also, there's a lot to tell about that. Again, we start from the ISA convention. So it's really, that's why I say we're a textbook IGO. It all goes back ultimately to the founding treaty as the primary source of law. And the convention, namely that Article 1 on privileges and immunities, that Annex 1 on privileges and immunities, in Article 25, foresees that when we conclude contracts, then the agency shall provide for arbitration. So that's very important. The arbitration clause shall specify the applicable law and the country where the arbitrators sit. And all that, obviously, without prejudice to ISA's special status as an intergovernmental organization. So reference will be made to the substantive law identified in the contract, specifically when a matter is not covered already by the contract itself or by the general clauses and conditions, but also for the interpretation of a contract provision that is ambiguous, that is unclear, or again, that is not specifically covered by what we call the ISA general clauses and conditions. There is also here a two-step procedure. We will have first a conciliation procedure before going to arbitration. Upon failure of reaching an amicable settlement, then we may indeed submit a dispute to arbitration, and that's a very specific procedure. And what we do here, and that's the only time in the ISA rules and regulations where we specifically refer to an external procedure, that is that the disputes arising out of the contract shall be finally settled in accordance with the rules of arbitration of the International Chamber of Commerce. Obviously, the award final, conclusive, binding on the parties, that is, I think, goes without saying. The enforcement of the award is governed by the rules of procedure in force in the country in which it is to be executed. So this is just a glimpse into the general clauses and conditions and the procurement regulations of ISA. That's, as I said, a world of its own. In the last part of my short intervention, let me focus on international agreements. Now, as I mentioned before, ISA can look back on a very, very rich body of agreement law, around 530 by now. So you can say in average, we get about 8 to 10 new international agreements every year. And among those are very, very diverse subjects. So we cover things that range from general framework cooperation agreements with another country, that would not be for a specific project, but rather outline and establish the frame conditions for cooperation, up to very specific agreements covering, for example, cooperative missions, cooperative space missions to explore celestial bodies. How we've just heard about the exciting prospects of going to celestial bodies and looking for resources, etc. These are typically things that if we do them in partnership with, be it a government or a governmental space agency of a non-member state, we would cover by such an international agreement. But also things that are, as I call it, always a bit in the shadow and, you know, not in the foreground, like deep space tracking and network operation cross-support agreements. So when we connect to spacecraft, this is for those of you who are not too familiar with the space world. Obviously, you need to maintain contact with spacecraft, and that requires that you have an antenna network around the world. And you need to put antenna even in countries that are not your member states, and that you would typically cover also by an international agreement. Now, needless to say that for all these agreements, arbitration is generally speaking the last resort of choice for dispute resolution. But it's important what I just said as a last resort. And it's quite interesting. I will tell you at the very end, the climax of this little speech is that there is not much practice on that, and there's a reason for that. Now, before we would resort to arbitration in our international cooperation activities, there's always consultation and negotiation. These are always, obviously, the preferred methods of any dispute resolution. But, and this is important, when we look at these 530 ISA agreements with international partners, there's a great variety of how we structure and how we word a dispute resolution clause. That's quite interesting. So there is no blueprint that we would apply in ISA, say, this is how we do it. The first stage, as I said, is always settlement through consultation, possibly negotiation. In very rare cases, by the way, we have very few agreements that have no dispute resolution clause at all. Nothing is in there. Now, some agreements have the mere possibility of resorting to an alternative dispute resolution mechanism. I would read you a classical sentence here that would read, any issues not settled through consultation may be pursued through further dispute resolution mechanisms as mutually agreed. So that's a standard sentence, and you will not find more than that in many of those agreements. That's it, full stop. The bulk of our international agreements, I would say, provides for arbitration in principle, establishes also the conditions usually based on which the arbitrators are chosen, provides also for the final binding quality of the award, but leaves the determination of both the seat and the procedure to the arbitrators. Then the classical sentence would be the arbitration tribunal shall determine its seat and its procedure. And in a very, very few cases, there is an even more detailed process foreseen, in particular for the appointment of arbitrators that can stretch. I've actually checked it yesterday. In some agreements that stretches over more than a page, so that's fairly detailed. That includes, for example, the invitation to the president of the ICJ, the International Court of Justice, to make necessary appointments, provided that these appointments cannot be made between the parties, provided, of course, that the president is not a national from an ESA member state or from the country of the other party. And last but not least, when we have an international agreement between us, ESA, and one of our member states, and that happens also, in that case, obviously, we refer again back to Article 17 of the ESA Convention. Now, to sum up, some statistics, and that's fairly straightforward. Article 17 of the ESA Convention, arbitration for and between member states and between member state ESA disputes, has never been activated in over half a century. Arbitration in our international agreements has never been activated in over half a century. And that's very interesting. And that has to do, and let's not forget that, with the specificities of international space cooperation. So the kind of cooperation that ESA is usually undertaking, it's not common to resort to arbitration at all. So a diplomatic solution between the parties is always, be it through consultation or negotiation, favored, as I said before, obviously where it is possible. And behind that is a thought that you will always need to maintain the relationship alive in principle. So international partners like ESA usually cooperate in such complex projects over such a long period of time, and in multiple projects, we invest decades into developing such a relationship that we have an interest to maintain that overall political relationship. That's not a legal sentence I make. We have an interest politically to maintain that relationship. And therefore, we will try everything possible to find other ways than resorting to a more formal process of dispute resolution. So Laura, with that, I have definitely consumed my time. So I hand back to you, but I hope this was an interesting short excursion into the world of ESA and dispute resolution.
Very interesting. Thank you, Alex. I have one short question. We are almost out of time, but I was wondering if you could say a quick word on how geopolitical tensions affect ESA agreements. I know it's politically sensitive, but if you can maybe say a word about this, I think that would be very interesting.
Yes. Obviously, it does. I mean, ESA is an international organization composed of many member states doing very complex projects together with international partners. The international relations strategy is something that the member states of ESA, together with the Director General in a very complex staggered procedure, determine. And there are influences. I would not say that you immediately see these influences in the legal text of an international agreement, because obviously it takes years to develop new projects. It takes years to negotiate, to get agreements through approval loops. So you don't have this one-to-one reaction in the legal text. But what you do have is, of course, that you have to look into how you apply an agreement. And maybe, say, I'm not saying something secret yet, it's out in the media, and you can read it in the press releases of ESA very recently. The ESA Council has actually given the mandate to the Director General to suspend the operation of an international agreement. That was done, and that's quite interesting, based on two legal grounds that we find in Articles 61 and 62 of the Vienna Convention on the Law of Treaties, namely the impossibility of operation the supervening impossibility of performance, and the fundamental change of circumstances. And based on the occurrence of these two issues in a very complex situation, and you know what I'm referring to, this was one of the very, very rare cases that such a decision was taken and activated. Generally speaking, even though geopolitically you have ups and downs and all kinds of things, generally speaking, in the international space world, you have a rather calm development of relations, and you don't have this knock-on effect, immediate knock-on effects, as I said, until recently at least.
Thank you. Yes.
And yeah, sorry, Laura, just to say the ISS is another example of that. That is really an international treaty with 15 different states operating. Tomorrow we have an ESA astronaut launching to the International Space Station, despite the current geopolitical situation that you see, and that's very important.
Yes, as tragic as the situation is, it's interesting situations for public international lawyers, I think. I apologize to the audience. We won't have time to get into the Q&A questions today. And I will hand over the microphone back to Chiara for her closing words. But I wanted to thank all of the speakers very much for participating today. And obviously, again, thank you to Thorsten and Chiara for hosting it. Thank you.